Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation, your resource for information regarding pursuing subrogation claims. In this video, we're going to talk about acts of God and how they may be a defense to your subrogation claim. An act of God is anything that's a natural condition outside the control of human beings. Many courts have held that it doesn't have to be unprecedented. So a storm could be an act of God. Earthquakes, hurricanes, tsunamis, all of those natural conditions that may cause losses in which you want to recover the money, a party may say, nope, that wasn't caused by me, that was caused by an act of God. When you're putting together your subrogation case, it's always important to go back to the fundamentals of what do you need to do to prove negligence. You have to show that the defendant had a duty, they breached that duty, their breach caused damages. Those four elements: duty, breach, causation, and damages. An act of God goes to the point of duty. In other words, if a defendant couldn't do anything to prevent the loss, then it's outside of their control and therefore an act of God, and they should not be held responsible. One thing that courts always look at is, if a defendant had taken proper care, would the harm have been avoided? If that's the case, then it's not an act of God. Let's look at what could be a Hollywood-type scenario, something you might see in a movie. A driver's going down the road. Everything is just perfectly fine. Nothing's going wrong with the vehicle. Traffic is not heavy. And all of a sudden, there's an earthquake. And the earth shreds. And the road gets torn up in front of them. And their car flips over and hits another car in another lane. That would be an act of God. Let's try and look at something that might be more realistic, though, for your cases. Trees falling on neighbor lawns. And if you want to see another video that focuses directly on owner liability when their trees on their property damage an adjacent homeowner or property owner, check out our On Subrogation video on trees falling. In this scenario, we'll just assume that the owner of property where the tree is had knowledge that their tree was not healthy, it was defective and posing a risk. Then a storm comes around. Not necessarily the biggest storm of all time, but certainly high winds, rains, enough that trees fall down. Now this owner's tree that was defective falls on the neighbor's yard. Would that owner of property be liable? Well, in that case, they have a duty to prevent damage to the adjacent property owner's land. They breached that because there was a tree that was defective, they knew it was defective, and they didn't do anything about it. So therefore, they allowed the risk to continue. What happened? The tree fell and it caused damages. That homeowner might claim, well, no, it was the storm. It caused loss. But in that case, the act of God defense wouldn't really be applicable because the tree fell because it was defective and the owner had a duty to correct it, to remedy it, to have the limbs taken off, to have the tree taken down. And even though maybe it's a storm that pushed that tree over, the owner still had the duty and they could have prevented that loss despite the storm. Therefore, act of God is not likely to occur. Now let's compare that to another case. Let's say a lightning strikes case. The landowner where the tree is located has no idea that there's anything wrong with the tree. In fact, maybe the tree is healthy. A storm comes along and a lightning bolt hits it and it breaks the tree apart and limbs fall and damage the adjacent landowner's property. In that case, is there a duty? Yes, the landowner needed to make sure that his trees were not going to cause risk or harm to the neighbors. Was there a breach? Well, no, not in this case. There was no indication that there was anything wrong with the tree, and even though storms do come, the landowner couldn't have done anything to prevent the lightning strike. Did it cause the loss? Well, certainly the tree falling or the limbs falling did cause the damage, so we have our fourth element. But again, because there was no duty, there couldn't be a breach, and therefore in the lightning strike case, it's not very likely that the landowner where the tree was located would be found liable. These cases, as you might suspect, come up a lot with storms. High winds, they move things around, they cause things to fall, and they cause damages. I had an interesting case where a construction crew was working on top of a building, and they left heavy objects. One of the objects was a wheelbarrow, they had shovels, and they left them on the top of this roof. Now, there were storms predicted for the next day, but when they closed down the site and they knew they weren't coming back the next day, they left all that construction material on top of a high building. Well, sure enough, that expected storm came and high winds did push those objects off, causing damage to adjacent property owners. Those construction workers tried to claim it was an act of God. It was a storm. What are we supposed to do? Storms happen and we just can't control them. But of course, in that case, they had a duty, not just to make sure that the property didn't fall and strike things, but they had to be aware there was a storm coming. They needed to secure that property, and therefore their duty was to make sure that everything was put away and secured for what could be expected with a reasonable storm. And when they failed to do so, they breached that duty, and it caused damage to those adjacent property owners. Other areas you might see are tents. A store puts up a tent in their parking lot to have some type of sidewalk sale. Sure enough, what happens? It gets a little windy that day. It doesn't even have to be an extraordinary storm or tornado, and that tent blows over and it hits somebody's car. What are they going to say? It's an act of God. The wind caused this to happen. But if they failed to secure that tent, or knowing that high winds were coming, failed to take that tent down, they still had a duty that could be breached, despite the fact that ultimately the tent was knocked over by winds. If you have any questions, feel free to email us at video@rathbonegroup.com. For our On Subrogation and Rathbone Group, I'm Jason Sullivan, and that's the long and short of it.